Welcome back, everyone, to Wolfstorff Rosenthal's continuing H-1B Toolkit for Employers webinar series. Today, we're talking about employee Q&A. My name is James Pinedo. I'm with WR's Knowledge Base team. Before we get started, we have a quick legal disclaimer. This does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consultation with one of our attorneys. Speaking of attorneys, we have a great presenter from the WR team ready to go today. His name is Joe Gloski. He's a senior attorney at our Boston office and a counsel to companies, organizations, and individuals on business and family immigration matters. He's a member of the American Immigration Lawyers Association and a law student liaison to AILA's New England chapter. He's got a great presentation all ready to go. We'll let Joe take it from here.
Hi, everybody, and thank you, James, for the introduction. I'm Joe Gloski from Wolfstorff Rosenthal, and today we're going to talk about frequently asked questions that H-1B or H-1B candidate employees might ask. We'll be talking about two main topics, travel and family issues. Before we move into those topics, I wanted to start off with two notes of caution. First, it's important to remember that facts matter. We'll be talking about some general topics today, but every case is different. Every case has its own facts, has its own idiosyncrasies, and it's really important to speak to an immigration attorney if you have questions about your particular case. Second, we all as immigration attorneys, we all kindly ask that you ask questions before you act, because we may be able to help you avoid any particular unpleasant situation, which in immigration sometimes can be very unpleasant. With that said, let's move on into the presentation. The first main topic that I wanted to discuss today is about travel. And the biggest question that immigration attorneys field and that HR representatives may field from their employees is, can I travel? And I would say the most important factor in deciding whether somebody can travel is where we are in the process. There's three different ways to think about where we might be in the process. One is before the case has been filed. The second is if the case is filed and pending. And the third is if the case has been approved, and in particularly in the H-1B context, if it's approved but not yet effective. So the first context to discuss is where before a case has been filed, and that is probably the best time to travel, provided that the individual has a valid status in the United States, they have the appropriate documentation, and most importantly, they'll be returning in time to file whatever needs to be filed. Then that's probably the best time for somebody to be traveling. Every case is different, and in some cases it might not be advisable to travel, but for the most part, it's probably where folks are the safest. Second is where a case has been filed and is pending with USCIS or immigration. It's important to consider whether a case has been filed with a request for a change of status or extension of stay, or if the case has been filed with a request for what's called consular notification. With a change of status petition or an extension of stay petition, departing the United States may have consequences for the petition. In particular, if somebody travels while a change of status petition is pending, then USCIS almost certainly will deny the change of status component of the request. It doesn't mean to say, I don't mean to say that USCIS will deny the H-1B petition, but they will almost certainly deny the request to automatically change that individual status from within the United States, which may require them to complete additional travel or to stay outside of the United States until they have received their H-1B and are able to process a visa and return to the country in H-1B status. In the extension of stay context, where somebody already holds H-1B status and is filing to extend their stay, then timing is going to be important. If they are traveling for a short period of time and processing times being what they are now, if the case is likely to be pending for several months and the individual has all the valid documentation, travel in that case may be okay. And I mentioned the difference between change of status and extension of stay and consular notification. So under consular notification, there has not been a request to change or extend the individual status while they remain in the United States. So in most circumstances, if somebody's requested consular notification, then they should be able to continue traveling in their current non-immigrant visa status. However, in some context, it may not be advisable to do so. In particular, if filing an H-1B petition may contradict what their intended purpose in the United States is. So it's important to keep in mind, even if you've requested consular notification, it's important to confirm with counsel that travel and return to the United States is not going to negatively impact the petition or their current immigration status. The last circumstance is where a petition has been approved but is not yet effective. And particularly, I'm thinking of where an individual has filed a change of status petition. Perhaps they hold F1 status as a student, and their case has been, their H-1B petition has been approved, but it's been approved before October 1st. H-1B petitions under the cap are not effective until October 1st or the approval date, whichever is later. So if a case is approved in the spring or summer, then even if it's been approved, they do not yet hold H-1B status. Once the case has been approved, it's possible to travel. However, those same concerns about not jeopardizing the individual's current immigration status are important here as well. And again, it's important to confirm with immigration counsel before completing that travel to make sure that it's not going to have any consequences on their status. Another common question that we field as it pertains to travel is if an individual needs a new visa stamp. And I think it's important when talking about visa stamps to remember what they are and what they aren't. First, the purpose of a visa stamp is a travel document. It is not a status document. You need an H-1B visa stamp if you wish to enter the United States in H-1B visa status. If you hold H-1B visa status and you're in the United States, you do not need to hold a valid H-1B visa stamp. So if you change your status from F1 to H-1B and you're remaining in the United States and you don't plan to travel, you do not have an immediate need to obtain an H-1B visa stamp. If you hold H-1B visa status or H-1B status and you extend your H-1B, H-1B status from within the United States and your visa stamp expires, that's okay. As long as you're not planning to travel, you have valid status. It's only when you're planning to depart the United States and return to the United States in H-1B status that you would need to process an H-1B visa stamp. Another important consideration with visa stamps is their validity. And it's important to remember that the validity period of an H-1B visa stamp is not always and often is not the same as the validity period of somebody's H-1B visa status. And so that's important to remember because in two contexts. One is reciprocity. So many countries, there are foreign nationals who hold H-1B visa status may not receive a visa stamp that is valid for the same period as their H-1B petition. That doesn't mean that their status should be limited to that validity. It only means that that travel document is valid only for that period. So you can still be admitted for the duration of your petition, even if your visa stamp is only valid for a particular period of time, as long as you're traveling and entering the country while that stamp is still valid. It's also important to remember that visa stamps are not employer specific. So it often happens in the extension or change of employer context that an individual may have in securing a new H-1B petition might have extended their status beyond the validity of a prior H-1B visa stamp, but that stamp might still be valid. And if that individual then wishes to travel to another country and then return to the United States in H-1B visa status, as long as their visa stamp is valid, they can still travel, and they would not need to process a new visa stamp in order to return, provided that they are also able to show that they have a valid H-1B petition and employment to return to. Another context where it's important to remember, the purpose of the visa stamp is when somebody's renewing their passport. When renewing their passport, they might have an H-1B petition, an H-1B visa stamp in their passport that's valid even if the passport is no longer valid. That doesn't mean that that the individual needs to go get a new H-1B visa stamp necessarily. What it means is that they might need to carry 2 passports. They might need to be able to show that they have a valid visa stamp and that they have a valid passport. And as long as they're able to show both, even if they're not within the same document, they should still be admitted into the United States in H-1B status. And finally, just as a general advisory, when considering travel on H-1B, foreign nationals need to remember not only that they need a valid stamp in order to return, but they also need to make sure that they're maintaining a valid passport. They're also needing to make sure that they are carrying proof of their status, which oftentimes includes proof of their employment. And if they're traveling in H-1B status, they need to be carrying their H-1B approval notice as well. Moving on to family issues. There's 2 primary questions that we see regarding family members. One is, can my spouse and can my children apply with me? For H-1B status, dependent visa holders apply for what's called H-4 visa status. Spouse and children under the age of 21 are eligible for H-4 status. First part of that analysis of whether a spouse or child can apply is should they apply? And in particular, if a spouse holds another immigration status, such as TN or F1, where they hold employment authorization from that status or are eligible for employment authorization from that status, then it may not be in their best interest to apply for H-4 dependent status, in particular for because of employment authorization, which we'll talk about in the next slide. Also, it's important to keep in mind that children would need to derive their status from one of their parents. If the children currently hold dependent status from the non-H-1B spouse or from a different H-1B spouse, then it may not be necessary to file for those children when the H-1B beneficiary is applying for H-1B. It's probably also important to mention that children do need to apply. There's no automatic change or transfer just because a parent changes or extends their status. An application does need to be filed on behalf of children as well. Another important consideration is, where are the family members? If they are outside of the United States, then no filing should be necessary with immigration here in the US. Instead, in order for those family members to acquire H-4 status and enter the United States in H-4 status, they would need to apply directly at the consulate for an H-4 visa stamp. And once they complete that H-4 visa stamping process, they would be able to enter the United States in H-4 and join the H-1B family member in the US. If the family members are in the United States and they need to change their status to H-4 or they need to extend their H-4 status, then the mechanism to do that is by filing Form I-539, either accompanying the H-1B beneficiary's petition or filing a separate separate application that references the H-1B beneficiary's approved or pending H-1B petition. And then the last topic to discuss today, in the second question concerning family members, and it's an important one for a lot of families, is can my spouse work if they hold H-4 visa status? And as we discussed before, what the spouse's status is makes a big difference. If they currently hold TN, F1, J1, or any other employment authorized status, or status that may permit employment authorization, then it may not be in the best interest of the spouse to apply for a change of status to H-4. The reason for that is because while there is an H-4 employment authorization document that spouses can apply for, only certain spouses can apply. And what that means is that you can only apply, or an H-4 spouse can only apply for an EAD if the H-1B beneficiary has either an approved I-140 or is eligible for extensions of their H-1B status beyond their 6-year stay on the basis of a pending or approved PERM or labor certification application. So it's not automatic that a spouse in H-4 status can apply for an EAD. The H-1B beneficiary needs to be moved along in the green card process sufficiently for the spouse to qualify. And I would note also regarding H-4 employment authorization, two related issues. One is processing delays with adjudicating those cases. USCIS has in recent years slowed their processing times for H-4 EAD applications to the extent that we see significant processing delays. The reason why that's important is because H-4 EAD H-4 EAD holders are not eligible for an automatic extension of their employment authorization with timely filing of an extension application or renewal application. If they apply, even if they apply well in advance, if their application is not approved before their current EAD expires, then there's a gap in their employment authorization, and they would not be able to work again until they have a valid EAD in hand. So another very important consideration when deciding whether or not a spouse will take on H-4 status for foreign nationals to consider. So that's all I wanted to cover for today, and I'll leave with my same starting points. One is to please be sure to remember that every case is different. Facts matter, and it's always very important to discuss with counsel the particular facts of your case before deciding how to proceed. And second, it's best to ask those questions before engaging in any activity or action or process that might have an impact on your status, because it is always better to figure out before the consequences have already attached to your case whether or not you should do what you're planning to do. Thank you so much for your time today, and have a great one. Have a great day. Thank you.